Okay, we will start in, we'll start in about a minute. And please sign into the attendance. Okay, please sign to the attendance. We'll get started in a moment. Okay. Okay, I think everyone's here. Any questions before we get started? Okay. All right, I see no questions. Please sign to the attendance, and let's do a quick question to get started. This is a numeric question. So your first question is for the poll. This should be easy. Congress's powers are enumerated in Article 1, Section blank. I'm looking for a number. Another 20 seconds. This one should be quick. Seconds.
Professor?
Yeah?
Would you mind dropping the link to the class notes for today?
Okay, it's in the same place they are always in, but I'll be happy to put it here.
Oh, thank you. I'll save it.
No. This is not the link for General. The link is the link to the folders in the syllabus, but this is the link for today's class notes.
Oh, thank you.
And even if you don't have that link, it should be on your app as well. Okay, stopping right there. All right, very good. 92% of you put Article 1, Section 8. That's correct. Some of you put 1, 2, or 3. I'm not sure what that is about, but that's a bad guess. But the answer here is Article 1, Section 8. All right, good. Second question. Oops, sorry. This one's a short answer. I'm looking for a word or words. A state law that conflicts with a federal law violates the blank clause. A state law that conflicts with a federal law violates the blank clause. Okay? All right, I'm going to stop in 5 seconds. 5, 4, 3, 2, 1. Very good. Supremacy clause is the correct answer. People spelled it wrong, but I'll accept that as well. Supremacy clause, that's fine. Supremacy clause, good. Supremacy. Spelling it 5 different ways, that's fine. Okay, the answer is supremacy clause. A couple people wrote commerce clause, that's wrong. A couple people put a necessary and proper clause, that's wrong. The supremacy clause is the provision of the Constitution that says federal laws are the supreme laws of the land. It could happen that a state law might violate the commerce clause, right? It happens. But that law becomes unconstitutional by virtue of the supremacy clause. Okay. Now, why did I ask these two questions to start off class today? I want you to start thinking about the text of the Constitution in a careful fashion, right? For the first, half of the semester, most questions I ask you will be based on the text of the Constitution. The second half of the semester, we go off to the races. It doesn't really matter anymore. But at least for the first half, I'm in comfortable ground by saying, what provision? What clause? Right? And I like you start thinking in these terms, right? Article 1, Section 8 is where we'll be living for the next couple weeks. The Commerce Clause, the taxing clause, the necessary and proper clause. The supremacy clause is not in Article 1, Section 8, it's in Article 6, but you still have to keep it in mind. Okay. All right, so questions that to get started. Very good. And spelling does not count. I won't dock you on spelling, but I'll just have to manually go in. The reason why I don't like multiple choice is because you can guess, and I like people actually typing in answers. It's a little bit harder to guess that way. But then I have to deal with spelling errors. All right, let's get started then. The topic for today continues our discussion on enumerated powers. Last class we did two primary cases involving enumerated powers. The first case was McCulloch against Maryland. McCulloch v. Maryland asked whether Congress has the power, the enumerated power, to charter a federal bank. Right? Does Congress have the enumerated power to charter a federal bank? The court said yes. The necessary and proper clause gives Congress that authority. The federal bank was not itself a regulation of interstate commerce. The federal bank was not itself a regulation of the taxing power. But the bank was a convenient or useful way of regulating commerce. The bank was a useful way of collecting taxes. In other words, the bank was a means to an end, right? The bank allowed the federal government to accomplish its other ends. And the court says the necessary and proper clause permits that exercise of federal power, right? The necessary and proper clause allows Congress to do stuff to carry into execution its other enumerated powers. So we see in the McCulloch case this expansion of what the federal government can and cannot do. Okay. The second case we study that's relevant is Gibbons against Ogden. This case interpreted the Commerce Clause, not the necessary and proper clause, but the Commerce Clause. And this case held that Congress has the power to regulate intercourse among the several states. Intercourse means the exchange. That includes sale. It also includes navigation. So when a boat goes from New Jersey to New York, that's intercourse among the states, and Congress can regulate it. And because Congress can regulate that activity, and they had regulated that activity, the state law was not valid. The state law ran afoul of the Supremacy Clause. So we're already seeing here this conflict, right, between state laws and federal laws. In McCulloch, the state of Maryland tried to tax the federal bank. The court says you can't do that. In Gibbons, New York tried to regulate the shipment of boats between the states. The court says you can't do that. All right, so in these two cases we've studied, McCulloch and Gibbons, the federal government wins. Right? The court finds that the government has this power. Today we'll do a bunch of cases. We have a lot of cases today, a lot more than usual. And in some cases the court finds that Congress has that power. And in other cases the court finds that Congress lacks that power. And we should start getting is a sense of whiplash. You're saying, well, Josh, why is this allowed and that's not? The court's approach to enumerated powers is not a straight line. It's not even a line like this. It's kind of like a curve. It goes like this, up and down. And if you watch the videos for this topic, I think they explain it quite well. Yeah, I made them, so I would think that. But I do think, objectively speaking, they help illustrate that the doctrine has not been a straight line. And at different points in time, the court has had different conceptions of the federal power. In some points, that's a very broad conception. At some points, a very narrow conception. So you have to understand it. Now, why am I making such a big deal about this timeline? The way I test you, people start paying attention, The way I test you is by putting you in a specific point in time. Right? I'll say the year is, 1864, or, the year is 1911, or the year is 1820, whatever the year happens to be. And you'll need to know what the precedents are at that given point in time. You can't look ahead. You know what happens later, but it doesn't really matter. You can't predict what will happen. All you know is what has happened in the past. So you need to be able to trace the development of this doctrine over time as it has developed. Right? You can't just start with 2020. You might have to stop with 1805. One of my favorite questions a couple of years ago was I situated the students before the Constitution was even ratified. No Constitution yet, no Supreme Court. Students had fun with that question. They didn't like it very much. But you need to understand how this doctrine develops. Right? I don't care about the big theories, but I want you to see how these things move over time. It's helpful to know. Okay. Questions so far? All right. All right, let's start then with the first case, which is United States against Dewitt. Who is next? Will someone kindly volunteer? Bryce, yes, thank you, I appreciate it. Would you want to give us the facts, please, in Dewitt?
Yes, sir. So the Congress enacted a law saying that you can't mix the words naphtha
Yeah.
and illuminating oils or knowingly sell or keep for sale the mixture. And Mr. Dewitt in Michigan was selling an oil made of petroleum. So they said he was violating the law, and then the court said that it's not Congress's power to regulate it, it's more of a state issue.
Very good. So Bryce, let me ask you a follow-up question if I can. Why was Congress banning the sale of this type of oil? It was basically petroleum-based oil.
Was it the temperature that the oil was burning at?
Well, what about the temperature? And by the way, if everyone can just rename themselves last name, comma, first, I'd appreciate it.
So the oil was inflammable at a less temperature.
That's true, but my question, Bryce, is why did Congress decide to ban the sale of this oil? What was their justification?
Like what power did they use? Or
Why? Why did Congress think they needed to ban this type of oil? What were they trying to achieve? Clay, you here?
And put a tax on the other one, and so
Oh.
by one they could collect the tax revenue from the other.
Say it one more time, Clay. I think you got it exact correct. Why did Congress ban these petroleum-based oils?
So they banned the petroleum-based oil because there's another oil that they had a tax on. So
very good.
banning my other option, I have to buy the oil that I will pay taxes on.
Yeah, this was to raise revenue. Thank you, Clay. This was to make money, right? So just let's make this simple. Congress had a tax on oil number 1, and they banned oil number 2. So what are you going to do? You're going to buy oil number 1 and pay the taxes, right? That's why Congress did this. They did it to make it easier to collect tax revenue. Okay, everyone see that? Matt, are you here? Matt R? Okay, so now my question to you is, what enumerated power did Congress rely on to ban the sale of this petroleum oil?
They definitely discussed the Commerce Clause.
Right, if you're the government lawyer, what clause of the Constitution do you rely on here? See, that's the question I'll keep asking.
Necessary and proper.
Which one is it? Commerce, necessary and proper?
necessary and proper.
Well, why can't it be the Commerce Clause?
Because the Commerce Clause is specific to regulate commerce within the several states, whereas Dewitt in this case was arguing that this exchange was only within the single state of.
Okay, good. Well, I'll come back to necessary and proper in a minute. Jose, you're on deck. But I wanted to focus on this for a minute. So Matthew, was DeWitt's sale of oil commerce among the several states? Was DeWitt's sale of oil commerce among the several states?
No, this was not commerce between the several states. It existed all between, within Michigan in this case.
Right, and what case tells us that? What case are we relying on for that? We only have a few cases so far. This question gets harder, by the way, as we get further in the semester, but this one's easy. What case were we relying on?
That was, wasn't it, is it Ogden?
Good. Very good. Gibbons v. Ogden. Okay, very good. Thank you, Matthew. Gibbons v. Ogden held that purely local sales is not for Congress. Right? The sale of this local oil is for the states to regulate. So Congress can't rely on its commerce power. Jose, now let's talk about necessary and proper. What's the argument that the necessary and proper clause gives Congress this power?
That it was necessary and proper to criminalize the sale of petroleum-based oils in order to effectively enforce the power to lay and collect taxes.
Well, walk me through this, right? What does that mean? It's necessary and proper to ban this oil to more effectively collect taxes. In your own words, explain what that means.
Yeah, so it's a means to an end, right? So
Good.
if they're trying to effectively lay and collect taxes
Lay and collect taxes on what? What are they taxing here?
on the local sale of oils,
Well, which kind of oil are they taxing? Are they taxing the sale of petroleum?
no, the non-petroleum.
That's it. Okay, very good. Thank you, Jose. That's a key point. In order to effectively tax non-petroleum oils, they have to ban petroleum oils, right? And this is the argument that the government puts forward. And the court by Chief Justice Chase rejects it. He says, no. This doesn't fit within McCulloch v. Maryland, right? He says this consequence is too remote, right? You can't ban activity A to tax activity B, right? You can't ban A in order to generate revenue for B. That's too distant. You can't do that. All right, everyone see that? This was a very early decision from the 1860s, 1869, where the court read narrowly Congress's powers. Is Dewitt consistent with McCulloch v. Maryland? Chase thinks so. My colleague Randy thinks so. I'm not sure. I think Chase may have read Marshall a little bit more narrowly, and we know they didn't really agree with broad federal power, but we can leave that aside for now. All right, questions on Dewitt? All right, Spencer, you're up in a second for the next case, but I want to just give some background. Today we have cash, right? Paper money. We also have coins. Although coins are in shortage now, no one has them anymore. They don't exist because people don't leave their houses anymore, right? But the coins we have are not actual valuable metals, right? A penny is not really made out of copper, right? A nickel is not really made out of silver, right? There's maybe a little bit of trace amounts, but they're mostly filler metals. Why? Because the value of the penny is a lot less than 1 cent, and it would be a waste of money to make actual copper in them. But there was a time when U.S. currency was actually made out of gold or silver. And the value of the coin was actually tied to the value of these valuable metals. Paper money, however, was controversial, right? Because paper money was not worth anything. It was only worth whatever the government said it was going to be worth. So if someone owes you a debt in silver, let's say you have a contract that says you pay the debt in silver, and they pay you with paper money instead, it's like, what is this? This is not worth what I bargained for. right? So people generally agree that Congress can issue paper money, right? They can do that. But the question in this case was not whether they could issue the paper money, it's whether they can make the money legal tender. Now, what does legal tender mean? Legal tender is a law that says you are required to accept paper money to satisfy a debt. Say that again. What legal tender means is you're required to accept paper money to satisfy a debt. If you look at any piece of US currency, a dollar bill, whatever, take out of your wallet, it will say, this is legal tender. Right? You've probably never noticed that before. It's there, it's on every piece of currency. And it basically means if you go to any business in the United States, they are required by law to accept that piece of paper. Right? They can't turn it away. If there's a mortgage or a loan, they have to accept that paper money. So now I'll ask the question I always ask. What enumerated power gives Congress the authority to mandate legal tender, right? What gives Congress the power to mandate paper money be accepted as legal tender? Again, we're not arguing can Congress print paper money. They can do that. That's okay. It's can they force people to accept the paper money? Now, one fun fact. We're dealing here with the Chase Court. Why is it called the Chase Court? Because it involves Chief Justice Salmon Chase. Salmon Chase was Lincoln's nominee to be Chief Justice. Before Chase was on the Supreme Court, he served as a Secretary of the Treasury. And as Secretary of the Treasury, he supported the Legal Tender Act. In fact, the government put his face on the $1 bill, which is called a greenback. But now, 8 years later, Chase is the Chief Justice, and he has to decide the law he previously supported was constitutional. Okay. Spencer, with that beautiful wind-up, this long singer lingering on pins and needles, you want to walk me through the Chief Justice's analysis, please?
Like, you want the case brief, or you want?
Give me whatever you want. Whatever, give me whatever you got.
Well, first, Miss Hepburn owed a debt to Mr. Griswold, and she tried to pay him back with paper notes, and he refused.
Good.
So he sued her.
By the way, why did he not want these paper notes?
Because they had previously contracted for her to pay back in, I think it was it gold and silver or
Mhm.
silver?
Mm-hmm.
And the paper notes pretty much, I think the idea at the time was that they didn't have any value compared to the coins
That's right.
that they had previously contracted.
Okay.
And so the issue was whether Congress had the power to make the notes, the legal tender that Mr. Griswold would have to accept from Hepburn as her payment of the debt.
Very good. Very good. All right. And what the court hold here, Spencer?
No, that Congress did not have the power to make him accept that, to make legal tender.
Okay. Tell me why.
I think it was because I think they said at the time because it wasn't necessary and proper, like it wasn't
What's it? Just be precise here. Whenever we say it, what
legal tender.
what legal tender?
Paper notes.
So just I'm picking you because I want to get terminology correct. What is the exact question in this case?
Whether Congress had the power to make notes of legal tender and payment of debts.
Right. And what law was challenged here? What's the name of that law?
Oh, let's see.
What's the name of this law? It's important. And Gresser, you're on deck in a second.
Legal Tender Act.
Very good. Okay. All right. Thanks, Spencer. You're good. All right. So the question here is the Legal Tender Act constitutional? Right? Is the Legal Tender Act constitutional? did the Constitution give Congress the power to enact the Legal Tender Act? So Gresha, you here? Okay, Gresha, so let me ask you this question. What enumerated power, I'm sorry, let me ask the question differently. Is there a specific power that gives Congress the authority to create legal tender, according to the court, paper money?
According to the court, no.
Okay, that's correct. What about the Commerce Clause?
I think the court said that that wasn't applicable because it wasn't the same as coining money.
Well, we'll get to the coining money in a minute, but is the Legal Tender Act a regulation of commerce among the several states?
No.
Are you guessing?
Yes.
What is commerce among the several states? Let's start with that.
I think it's just making a law that applies to several states rather than just.
Whoa. What is regulating commerce? You said making a law. What is commerce?
It's.
What's that word? Makes people giggle. What's the definition of commerce?
Was that navigation or no?
Well, navigation for sure, but what's the broader category? What's that phrase that Chief Justice Marshall used? Colin, you here?
Yes, sir.
What's commerce?
It's intercourse.
Intercourse, right? Colin is right. Intercourse is what's commerce, right? Colin, is the Legal Tender Act a regulation of commerce among the several states?
I would say yes.
Why do you say yes?
I mean, I guess it's creating a uniform, it's a uniform payment among the states.
Is that what the court holds?
No.
So you think the court's wrong?
I mean, I had disagreements with it.
You're allowed to.
I'm
You're
not as smart as you, so.
no. Oh God, never say that. I don't know everything. And you're allowed to disagree. By the way, I mean that sincerely. I actually think the court's wrong here. I think the court actually got it wrong, but for other reasons. So you think the court got it wrong? Is that what you're hinting at?
I mean, I understand the argument of by creating like a uniform piece of payment or a uniform piece of currency that you are in fact regulating commerce between the states.
But this was a local transaction in Kentucky.
True. So in that, then yeah.
So let me I want to push you on this for a second. So if someone's putting paper money across the border, it's okay, but if it's within one state, it's not?
If it's within a state, then it's a policing power, and that's reserved to the state.
So you see that, I think, Colin, you raise a fair point. The line between local and uniform national is tricky, isn't it?
Yes, sir.
Very good. But does Chief Justice Chase think this is a regulation of commerce?
He does not.
Yeah, that's right. Chief Justice Chase here holds, and thank you, Colin. Chief Justice Chase here holds that the Legal Tender Act is not a regulation of interstate commerce. He also says that this is not coining money. And I want to just pause here. When you hear the word coin, you think of a metallic disc, right? Like a little penny or a quarter. It's not entirely clear that coin only meant metallic money. I think there's a credible argument that coin could refer to paper money as well. It's a word we don't use anymore. But I think there might be problems with the Chase opinion in a lot of regards. But then he gets a necessary and proper clause, right? And that's the more important part of the case. Ashley, are you here?
Yes.
Actually, what does Chase think about the necessary and proper clause? I think you're on mute. I can't hear you. There you go.
He didn't think that it gave them the power to make people use dollars.
Why?
Because it didn't apply to any power extremely vested.
Well, right, there's no express power to coin paper money. But let me go back to Colin's point a minute ago. Wouldn't it be useful to Congress to have a single nationwide scheme of money to facilitate trade among the states? Wouldn't that be a useful thing to have? Isn't this like the national bank?
Yeah, which I disagree with. I think it, in a broad kind of indirect, using the direct indirect test for necessary and proper is the kind of argument for it to apply. But Chase disagrees with that.
Right, so Ashley, let me ask you a follow-up. Do you think Chase is fairly reading McCulloch, or he's reading it maybe more narrowly, the necessary and proper clause?
I think he's reading it more narrowly than Marshall.
Yeah, I think you're right. Thank you, Ashley. So I think what you have here is you're seeing, two justices about 40 years apart reading the same clause differently. Marshall said that the national bank was a necessary and proper means to regulate commerce among the several states, right? If you have a bank in every branch, in every state, you can have people depositing dollars there. You can have, repositories of federal currency. It makes things easier. Does having a single uniform paper money scheme make regulation of interstate commerce more effective? Probably, right? So I think arguably the necessary and proper clause might give Congress this sort of authority. It's not the Commerce Clause by itself, but it's a necessary and proper clause. You have this national scheme of money and you want to have a single uniform currency. I go back and forth on this. This year I tend to think that Chase got it wrong. Some years I think Chase got it right. If you watched me last year, I said the opposite. I don't remember. But I go back and forth. I try at least to be consistent in one semester, but I don't promise much more than that. And by the way, you're allowed to disagree with the court. I mean that sincerely. If you think the court gets it wrong, you say so and you raise your hand and you tell me why they're wrong. These justices are not gods. This was it wasn't 5-4, it was a 4-3 case, but it was sharply divided. And by the way, the court reversed itself a couple years, barely a year later. Lainey, go ahead, please.
So I don't know if this fits in here, but I've been waiting in law school to find out about Bitcoin.
What about Bitcoin?
Is the government able to regulate it as currency?
Sure. Well, it's not. Bitcoin is not legal tender, right? It's not issued by the government. It's a private cryptocurrency. If I go to a store and I offer to pay them for my groceries with Bitcoin, they'll say get lost, right? Or they'll take it. Who knows? There's no requirement to accept Bitcoin. So it's a private transaction market. Can the government tax it? Well, sure they can. It's a form of transfer of wealth. I don't care if you transfer money using gold coins or pieces of scrap. If you accept anything that is valuable, it's taxable income. All right? If instead of paying you, I give you a brand new car, right? Like Oprah. I mean that's a classic example. When Oprah gave all of her people in her audience brand new cars, that was taxable income. They had to not pay taxes on those cars. A lot of people couldn't afford those taxes. So it's sort of a, and then I actually think Oprah tried paying the taxes, and even the paying of the taxes, that's taxable income. So basically you're screwed no matter what, right? Anything you get that's valuable, Uncle Sam can tax it. You get a car, and remember that one. Okay, other questions? I'm sure your tax professor knows much more about this than I do, but I can at least give you this much about it. All right. Now comes the tricky part. When Hepburn was actually decided, the vote was 4-3. Let me ask this question. This is, I think, Question number 4. Is it true or false? This is on your polling device, please. Did Hepburn versus Griswold strike down the Legal Tender Act? True or false? Another 15 seconds. Five more seconds. All right, I'll stop it there. Ooh, okay. So, Lauren, I think you are up next. You here?
Hi, yeah.
Lauren, what'd you put here? Oh, you dropped off.
Sorry, I put, true.
Okay. Let me ask you a follow-up, please. What does it mean for a court to strike down a law?
I guess it would declare it unconstitutional.
Oh, okay, well, I like declaring constitutional. What does it mean to strike the law down? What does it actually mean? People use this phrase all the time. They don't know what it means.
Like, cancel it, kind of?
Yeah, like hashtag canceled? Yeah. So does that mean the law's gone, it can never come back?
Obviously not.
Oh, what do you mean obviously not?
Well, because they went back on it later. I mean, we have legal tender, so.
Oh, so what does it mean to strike down? What does that phrase mean?
Then, I guess, then it's to, I guess, send it back down. Like, you could kind of look at it like that, say, you know, this needs to be changed or something needs to happen because doesn't quite fit.
Yeah, I'm sorry, Lauren. You're giving me very good answers. I don't mean to give you a hard time, but I don't like the word strike down. I try very hard not to use it. You'll find it in the 3rd edition of your book. The 4th edition, gone. I actually did a Control F for all strike downs, and I got rid of all of them. This book is such a pain in the neck to revise, like 2,000 pages. But Randy and I were working our tails off, so maybe another year or so. We'll be probably, I think it'll be done by December of 21. The new edition will be out, but you're stuck with this one. But I don't like the phrase strike down because it seems like, the court takes like a red pen and just like strikes it out. Like you cross something out in a contract that you don't need it. Courts cannot strike laws down. If they did, what the hell is a legal tender case? Knox v. Lee. How do you have a law that's unstruck down? That's not even possible. So I use this case to illustrate what courts do and what courts don't do. Courts have the power to declare laws unconstitutional. I think Lauren said declare, I like that word. Right, so in Hepburn, the court said that the Legal Tender Act is unconstitutional. Yet, other people still try to make people accept legal tender. And then you get to Knox against Lee, and the court says, never mind, we disagree. Okay? So everyone just get that little point. This is a Josh thing. Most professors say, strike down, strike down, strike down. You get a strike, and you get a strike. I don't like that phrasing because I think it's not accurate. It creates this appearance of the judges being way too powerful, and they have enough damn power. They don't need more. All right, I'm who before said, I don't want to criticize the justice. Oh, wait till I start. I don't hold back. They're not gods. Okay, next question. Question number 5 for the poll, please. This will be a short answer. Congress relied on the blank clause to uphold the Legal Tender Act. And James, I see your hand up. I'll get you in a second, I promise. Congress relied on the blank clause to uphold the Legal Tender Act. Give about 30 more seconds. And I do appreciate you guys are putting your polling questions in quicker. It helps the class move a little more fluidly to accommodate for our less time. Five more seconds. Okay. All right. Very good. The answer here is necessary and proper, which most of you got that. Very good. People spelled in every which way. necessary and proper, necessary and proper, necessary and proper. Oh boy, I think I have a dozen different ways of spelling necessary and proper. I'll fix all these later. Now, someone wrote commerce and necessary and proper. That is not correct. The court focuses on necessary and proper. Wow, how many different ways can you spell necessary? This is N and P. Okay, that's good also. Okay, but the short answer here is necessary and proper. Less than a year after Hepburn was decided, the court renders Knox against Lee. What changed? President Ulysses S. Grant appointed 2 new justices, and these justices were known to support paper money. And the court adopted a broad reading of Congress's necessary and proper powers. Now again, the court does not say that the commerce power by itself is sufficient. Instead, they look to necessary and proper clause. Right? And the court relies on what's called an implied power. Now, what does this phrase mean, implied powers? Well, implied is the opposite of express. You have express powers and implied powers. Congress has the express power to regulate interstate commerce, but they have the implied power to do much more than that. Right? And the court says an implied power needs to have just some connection to something in the Constitution. Right? If Congress has some general interest in commerce, doesn't really matter what it is, if there's a connection between paper money and commerce, that's good enough. Right? You see what's going on here? I think it was Colin a minute ago said, well, it's really helpful to have paper money to have this national economy. Right? That seems like a pretty good justification. I think we could argue that in good faith. But the court goes beyond that. They say that any connection, any power in that general ballpark gives Congress an implied power. If you take Knox v. Lee seriously, the powers of the government become unlimited. And this is what Justice Chase wrote in dissent. Justice Chase says that if you use the majority's approach, there are no limits. If anything that relates to the federal government is helpful, whatever, good enough, then the federal government has an absolute power. The federal government has what's in effect a police power that the states usually have. People often think that the New Deal, the 1930s, represented the expansion of federal power. But this case, Knox against Lee, was a preview of things to come. The Knox court adopted an authority that would give Congress really a blank check to do whatever they wanted. Later courts would try to peel this back, but this was a very broad decision for the 1870s. Okay. Questions? I think James had his hand up a minute ago.
No, you answered it already in your discussion.
I knew I would. Thank you, though. I appreciate it. Whenever I see a hand goes down, I'm like, okay, nailed it. And I don't take this the wrong way, but students, how do I put this, are predictable, right? Year after year, students ask the same questions at the same point in time. It's the scariest thing. It's like the human mind works in a fairly linear fashion. Everyone's brain's different, but people usually reach the same questions at the same point in time. So I can usually predict at a given point in the lecture exactly where people will become confused, and I can anticipate those questions. And this is just by teaching this many times. It's not any sort of, it doesn't come automatically. It took me a while, but like I know roughly when things become unclear, and I can anticipate those questions. So I see hands going up and down. I'm happy. Yes, Lainey, prove me wrong. What did I miss?
Well, I'm so predictable. What's my question?
Oh boy. I don't know. Go for it.
Is Chief Justice Chase where we eventually got Chase Bank?
Yes. In fact, Chase National Bank was named after Chief Justice Chase. That's exactly right. Yeah, Justice Chase was a fascinating guy. I'll just talk about him for a minute. He came of age as a lawyer in Cincinnati, Ohio. And what made him famous on the national stage was his opposition to slavery. And he litigated a case involving a runaway slave. And he actually argued that Congress could not require the return of these runaway slaves. He lost that case, but he built a reputation for himself, and he gained the nickname the Attorney General for Runaway Slaves. That became like his thing. He was a very prominent lawyer in this area. He came up into politics in Ohio. He helped found several political parties. In the 1860, Chase and Lincoln were both fighting for the nomination for the Republican Party. Lincoln prevailed over Chase. They were rivals. But then after Lincoln won the election in 1860, Lincoln picked Chase as his Secretary of the Treasury, and Chase was basically presiding over the War Department, of the war effort during the Civil War. He was helping to raise finances. And it was in this capacity that Chase was supporting the paper money and supporting the Illegal Tender Act. But Chase is a fascinating guy. We'll talk about him more. My colleague Randy is a huge Salmon Chase fan. He visited his grave in Cincinnati. He's very much into Chase, so you'll see a lot of that in our book. So funny. I talk about Randy. Randy's at Georgetown, Barnett. He talks about me. He always complains about how I make these edits and drive him crazy. And whenever there's any error in the book, it's invariably my fault. So it probably is. But we talk about we talk about each other, sort of subtweeting. All right. Questions on Hepburn? Questions on Knox? Questions on Dewitt? Stuart, yes, go ahead.
So I'm just thinking, like, this 1870s, it's relatively close to the European ties. Do they have any precedent that did Europe use the uniform national currency at this time?
I have no idea. I have no idea. I don't know.
Fair enough.
Paper money wasn't new. The states had issued paper money before the ratification of the Constitution. The concern was actually not so much the federal government. The concern was actually the states issuing paper money, because that creates debt, because the paper money was basically worthless. Okay. Questions on DeWitt, Prigg, or Knox?
I have a question for curiosity's sake.
Who's this talking? Just raise your hand, please, before you start talking. Who's this?
Victoria Harmeyer, sorry.
Yep, go ahead. Just it makes it easier if I can call on you, then you're welcome to speak. Go ahead.
Got it. For the DeWitt case, why was Congress not just able to tax petroleum-based eliminating oils?
Oh, they could. They could have, but instead they wanted to ban it altogether, right? They wanted to ban it to tax to create revenue for the other item. But they were welcome to tax the the petroleum oils. They could have done that.
Okay.
Make sense?
Yeah, not the way that I would want to go about it, but yeah, it makes sense.
Okay. Very good. Thank you. Laura, go ahead.
So when we get tested, are we going to be tested over Knox? Because Knox wasn't in the syllabus, so I just kind of knew that it's what reversed it later.
Hold on. Was it? Yeah, I mean, it's in the discussion of what happened next, right? There's that little box I did ask you to read.
Yeah, and I read that, but I just didn't read like the full. I'm now
No,
like it's like.
yeah, no, I understand, right? But we talked about in class, so that's what I'd like you to know from it. The rely on necessary and proper clause.
Okay, thank you.
Yep, but fair question. Yeah, in general, if I talk about something in class, then it's what I said in class is fair game. I for your benefit, I trim the readings. I told you this. We just don't have enough time to do everything, which sucks for me. But do the best we can. Other questions? No? All right. Let's move on. We started this class with the 1800s with the Marshall Court. We just concluded the Chase Court in the 1860s, in the 1870s. Now we jump a bit to the 1890s. And we enter an era that's often called the Progressive Era. And maybe you studied this in high school or college. The Progressive Era, late 1800s, early 1900s, there's no specific start and stop date. But the Progressive Era was known for a lot of things. One of the things the Progressive Era was known for was using the power of the state and the federal government to create social reforms, to create economic reforms, to create political reforms. Some of these reforms were positive. For example, suffrage, right, the right to vote for women. Some of these reforms were maybe not so popular, or not so positive. Under the original Constitution, we had direct election of senators. I'm sorry, we had senators were picked by the state legislatures, but progressives pushed for direct election of senators. We had another amendment banning alcohol, right? The 18th Amendment, maybe not so popular today. Progressives had a lot of laws that they wanted to enact. But the progressives were often met by resistance, not in the political process, but in the courts. And in many cases, not all, but in many cases, the court held that these progressive laws were unconstitutional. Later in the semester, we'll consider state progressive laws and whether state progressive laws violated the 14th Amendment. But today we'll be studying federal progressive laws. Again, we'll do state laws later, and here we'll do federal laws. Specifically, we ask, do these federal laws violate Congress's enumerated powers? In other words, is Congress trying to regulate stuff that they lack the power to regulate? Questions on that introduction? You can read books and books and books on the Progressive Era, but I won't bore you. All right, let's start with a question. So it's multiple choice. According to the majority, United States versus E.C. Knight, which comes first? Commerce or manufacture? Commerce? I'm sorry?
You mean chronologically?
Answer the question. If you're not sure, then this should be an easy question. Okay, another 5 more seconds. I appreciate people want to ask clarifying questions, but just put an answer. I'll talk about it. So it's not helpful to litigate the question while the poll's running. All right. Oh, well, that's pretty good. 92% of you got the right answer, which is manufacture. Now, today, I think in common discourse, the phrase commerce tends to mean everything commercial, right? All economic activity, all commercial activity is commerce. But that's not the definition of commerce adopted in Gibbons against Ogden. See, we keep coming back to Gibbons over and over again. Commerce is intercourse, right? It's navigation. It's transferring goods from one place to another. But manufacture was understood to be separate from commerce. Indeed, manufacturing came before commerce, right? You would manufacture stuff. You would make stuff, sugar or whatever else, and then you'd ship it. Right, so there are 2 steps. First you make it, and then you ship it. I could substitute manufacturing for farming, right? You grow crops locally, and then you ship the crops. Right? You slaughter some animals locally, and then you ship the meat. You make some wine locally, and you ship the wine. Right, so the understanding there are 2 steps in the process, right? You would do something locally, and then you'd ship it. Everyone agreed that Congress could regulate the stuff you're actually shipping in interstate commerce, right? So if you're shipping goods across state lines, Congress can then regulate that activity. But can Congress regulate what comes before the shipment? What comes before the intercourse? What comes before the commerce? That is, can Congress regulate the manufacturing process? And that's the issue in our first case, United States against E.C. Knight. Okay. Who's next? Is it Aaron or James? I can't remember who's next.
It's me. I haven't gone yet.
Okay, Aaron, thank you. You want to give me the facts, please, in E.C. Knight?
Yes, so basically Congress passed the Sherman Antitrust Act, which basically criminalized monopolies. And so the American Sugar Refining Company basically bought out 4 other sugar refineries. And so that gave the American Sugar Refining Company a monopoly.
Mm-hmm.
And so the United States was basically arguing that in doing that, they violated the Sherman Act, or the Sherman Antitrust Act.
Good.
And so the court ended up ruling that they weren't violating the act because it wasn't technically commerce, it was just manufacturing, which, like you said, isn't commerce, according to this court.
Okay, very good. Thank you, Aaron. That's excellent. You've probably all heard of the phrase monopoly. Maybe you play the board game or the app now, I suppose. A monopoly is a concept in economics where one firm controls too much of the market share. In the late 1800s, there was a movement towards what we call consolidation, where these huge firms or trusts would acquire their competitors. You know, Standard Oil, right? The railroad trust, these huge companies that would basically buy all their competitors, United States Steel. And there was a fear that if one firm owned too much of an industry, they could then raise prices. Therefore, the government can come in and break up the trust busters, as Teddy Roosevelt famously called it. Now, the states were not well equipped to bust up these monopolies, because very often these monopolies held interest in many states. And, you know, New York couldn't regulate a New Jersey corporation, and New Jersey couldn't regulate a New York corporation. So if there's ever any government that could enforce antitrust laws, it would be the federal government. Congress then enacts the Sherman Antitrust Act to prohibit these large trusts, to prohibit these monopolies. And then the government brings a suit against the E.C. Knight Company, which it accused of making a monopoly. But what does it actually mean to make monopoly? The product of their refineries, right, the sugar that they were producing, constituted 30-something% of the marketplace. The government was not charging that the shipment of the sugar was the problem. The government charged that the production of the sugar, the manufacture of the sugar, was the problem. And they brought a prosecution against the E.C. Knight Company for the sugar monopoly. The court rejects this power. And the court says very clearly, commerce comes after manufacturing. Commerce succeeds to manufacture. Commerce is not part of manufacturing. First you have the manufacturer, and second you have the commerce. All right? In this case, Congress was regulating the manufacture and not the commerce itself. Therefore, this prosecution was unconstitutional. The court didn't say that the Sherman antitrust law was void on its face, but in this case, the prosecution was not permissible. And the court draws this phrase, I think someone said it earlier, between primary regulations of commerce and secondary regulations. You go primary, secondary, or direct, indirect. You see it both ways. Direct, indirect, I prefer. This was not a direct regulation of commerce. It was an indirect regulation of commerce. How is it indirect? Because they weren't regulating the shipment of the goods, they were regulating the sugar itself. Right? Rather than saying, okay, you can make all the sugar you want, you just can't ship it, they said, well, you can't even make it in the first place. Had Congress said you can't ship this monopoly, that would be a different story, but they tried to ban the manufacturer in the first place. And the majority held that this was not a permissible regulation of interstate commerce. Okay, questions on that? Now, James, walk me through the dissent from Justice Harlan. Oh, I'm sorry, Denver, you have a question? I'm sorry.
Was it direct or indirect? I didn't catch that.
The majority said this was an indirect regulation of commerce.
Thank you.
My pleasure. James, you here?
Yes, sir.
James, you want to give me the dissent by Justice Harlan?
As best I can, yeah. But he basically says that this line that they're drawing about when this becomes commerce is flawed, and this actually is commerce if you apply the means end scrutiny.
How so?
That the end proposed to be accomplished by this act is the protection of trade and commerce among states against unlawful restraints. So like that they're manufacturing this sugar, but it's not just staying in, I think it was Pennsylvania where these plants were, but it's going everywhere. So to draw this line is sort of arbitrary.
Mm-hmm.
And that the government is the one who does have the power to regulate this, and nobody else, and so that they should use that power.
Let me ask you a follow-up question if I can, James. When you say means end, right, what clause of the Constitution are you talking about?
Necessary.
Does Justice Harlan mention the necessary and proper clause?
No, sir.
No, he does not. He only mentions commerce, right?
Yes, sir.
Yeah, thank you, James. That was very good. One of the trickier parts of this entire topic is that the justices often don't tell you what they're doing. Right? Justice Harlan says, oh, this is commerce, this is commerce. But he doesn't actually say that. Right? He's not saying that the local manufacturer of sugar is commerce among the several states. Instead, what he's saying is that Congress can ban this local manufacturer of sugar in order to prevent it from spreading in other states. In other words, once it's made, people are going to ship it. So wouldn't it be useful for Congress to ban it in the first place? That way it's not shipped? That's what Harlan's getting at. To prevent this awful sugar from flooding the marketplace with these prices, you just ban it from being made in the first place. That's a necessary and proper case. And that's McCulloch v. Maryland. Right? But the court doesn't cite McCulloch. The dissent doesn't cite McCulloch. It's this very strange thing that always gives students difficulty, and frankly most law professors difficulty. It's that they're using necessary and proper without saying so. Alright, so questions on EC Knight? Yes, Macy, go ahead.
So are you saying that Justice Harlan is saying we need to use the necessary and proper clause to protect Congress's commerce power?
Yes.
Okay. I'm just making sure.
Yeah. So the argument's this, right? Congress wants to protect commerce from these unlawful restraints, right? Congress wants to protect commerce from these monopolies because having these monopolies is very bad for prices nationwide. And in order to protect this commerce, the way you do is by shutting down monopolies. And the way you shut down monopolies, you ban their production of sugar, right? It's too risky to let them make the sugar because it's going to spill into the market, right? Once the sugar exists, it's going to find its way into the marketplace. The only way to prevent this sugar from finding its way to the marketplace is prevent its manufacture in the first instance. That makes sense, Macy?
Yes, thank you.
Of course. Other questions? NEC night? Okay. Any other questions before I go into the next case, please? All right. Take a look at question number 7. Which clause allows Congress to prohibit the interstate shipment of lottery tickets? Sorry. The 15 seconds. Five more seconds. Okay, I think I got everyone. All right, that's what we got. Okay. Stop it right there. All right, so 66% of you put A, and 15% of you put, sorry, 25% of you put all of the above, both of them. And a couple people put none of the above. All right. Bianca, are you here?
Yes, I'm here.
Okay. All right, Bianca, what'd you put here?
I put a commerce clause.
Okay. Why do you say commerce clause?
Because in this case, it talks about shipping the lottery tickets from one state to another, so that made me think of like intercourse between states.
Okay. Very good. Let's see. Seth, what'd you put?
I put A as well.
Okay. Well, Seth, let me ask you a follow-up question. The key word in that phrase is prohibit. What does the Commerce Clause allow Congress to do?
It allows it to regulate interstate.
Does the power to regulate commerce include the power to prohibit commerce?
It's not expressly provided. So, based upon this court's interpretation, it does.
Ah, okay, very good. So the answer here is A. This is one of the rare cases the court relies entirely on the Commerce Clause and doesn't really involve the necessary and proper clause. Okay, this is Champion versus Ames. Okie dokie. Smiha, are you here?
Yes, I'm here.
Smiha, could you give me the facts, please, in Champion against Ames?
Sure. So we have the appellant's Dewitt.
Oh, I'm sorry. I think I might muted by mistake. I apologize.
Oh, that's okay. This case is about the American Lottery Company shipping lottery tickets from Texas to California using the railway system, I guess, the railway.
Good.
And basically what this case talks about is trying to define commerce and I think there's one more word, there's 2 words I don't want to commerce and regulate.
Good. Okay. So, in this case, which provision of the Constitution empowers Congress to prohibit the shipment of these lottery tickets?
So I think the case talks about how there isn't an express way where it talks about prohibiting, because the Commerce Clause only talks about regulating and it doesn't specifically say prohibiting.
Okay, very good. All right, thank you, Smiha. So we have this case, right? And this case seems to be in tension with the previous case. We have E.C. Knight, and E.C. Knight holds that Congress can't regulate local manufacture, but Congress can regulate the shipment of commerce. Right? This case is not about manufacturing. It's about the actual shipment of the lottery tickets. And in some regards, this seems to follow from E.C. Knight. But the difference here is that Congress is not merely regulating how the lottery tickets are transported. Congress is banning their existence in interstate commerce. Right? It's banning the existence of interstate commerce. So, is Douglas, you here, Douglas?
Yes, sir.
Now, Justice Fuller wrote the majority opinion E.C. Knight, but here he's in dissent. What's Fuller's argument here?
So, he's saying that this was a police power that is given to the states.
Why does he think this power was given to the states?
Because Congress is empowered to regulate commerce between the several states, and therefore using this power to suppress the lotteries is using a police power that they don't actually have.
Right, but what's the problem if Congress is enacting this law? Why is this problematic? If Congress bans the shipment of lottery tickets, what does that do to the states?
It's transforming a non-commercial article into a commercial one simply because it's transported.
No, but my question is, what does it do to the state's police power if Congress can intervene here and ban it all outright?
Oh, okay. It completely diminishes the police power.
That's what I'm looking for. Thank you, Douglas, right? If Congress can ban their shipment among states, it basically takes that authority away from the states. Right? Whenever you expand the power of the federal government, you will contract the power of the states. Right? It's sort of like make one bigger, the other one shrinks, like that kind of relationship. And by banning, by allowing Congress to ban these, you basically make it impossible for the states to have these sorts of lottery tickets. The lotteries be done by the states. And you're asking, why are they banning lottery tickets? This was a sort of morality issue. It's related to prohibition. You got to ban alcohol, you got to ban gambling, you have to ban all these awful things that people do because it makes people evil, or something like that. All right, so again, Fuller was the majority in E.C. Knight, and Harlan was in dissent. And then a couple years later, Fuller was in the dissent, and Harlan was in the majority. So this sort of flipped around back and forth in the span of a few years. Any question on Hammer? I'm sorry, I'm not Hammer yet. Any questions on E.C. Knight or on Champion v. Ames, the lottery case? All right, Rachel, are you here?
Sorry, I'm here. I keep this on.
That's okay. Rachel, give me the facts in Hammer v. Dagenhart, please.
Okay, in Hammer v. Dagenhart, there was a lawsuit filed in Western District, North Carolina, by a father on behalf of his child and I believe other children that were subject to child labor conditions. The district court.
No, let me just pause for a second. Were they in favor of the child labor laws or opposed to them?
No, they were opposed.
So just I'll make sure I understand this. These were children who wanted to work. Is that what you,
No. They didn't want to work. They were trying to enjoin the enforcement of a congressional act that banned interstate commerce that was.
hold on, I think you said two different things. Did these kids want to work, or they wanted to not work?
They did not want to work.
Oh. These kids were suing for the right to work.
Oh, I'm sorry. That's what I meant. I apologize.
That's okay. I make this point because it's somewhat counterintuitive. Usually you think of children going to court to say, no, we shouldn't have to work. Right? Child labor is bad. But here, the kids, by virtue of their father, were suing to say that this federal prohibition is unconstitutional and they should be allowed to work if they want to. Is that right, Rachel? Okay, all right, go on. Continue, please.
All right, the district court said that that was unconstitutional and had appealed went to the Supreme Court. What the Supreme Court was trying to figure out is if it was constitutional for Congress to regulate interstate commerce through prohibiting the transportation of goods made by, the interstate transportation of goods made by child labor.
Okay, good. By the way, what's that backdrop? Very pretty backdrop you have.
My home state of Connecticut.
Oh, where in Connecticut is that?
That I think is in Waterbury. I'm from Fairfield County.
Oh, very good. Appreciate that, thank you. Right, so here we have a case where children in North Carolina are arguing that the federal ban on child labor is unconstitutional. Now, let's be precise here, let's just be careful. North Carolina law permitted children to work. Did the federal law prevent children from working? Shane, are you here?
It's Shawnee.
I'm sorry. Shawnee, did the federal law prevent the children from working?
No.
Okay, that's correct. What exactly did the federal law do?
It.
Right. What exactly did this federal law accomplish?
It.
Do you have it?
Yeah, okay, so the federal law allowed children under the age of 14 employment or like permission to work.
No. Rupa, are you here? Rupa, you here? Gisela, you here?
I'm here.
What exactly did this federal law do?
I know that it like allowed children to work, but
What did the federal law ban?
it banned the transportation of
That's it.
commerce and
Right. So one more, I'll just ask you a follow-up, Gisela. The law banned the shipment of products manufactured by children, right? Gisela, why didn't Congress just outright ban child labor? Why couldn't they ban child labor outright?
because wasn't that like something for the state, like a state power?
Yes. What case tells you that? Now, see, I'm trying to build your cases up, right? What case tells you that Congress can't ban local child labor?
That would be
That's a start. A more recent case, or a case closer to what we're studying now.
that would
That's exactly right. And what did E.C. Knight hold?
That if it was like indirect, then if it was an indirect way of commerce, then it can't regulate it.
Right. So E.C. Knight held that you can't regulate commerce indirectly. All right. So in this case, thank you, Gisela. Right. So in this case, Congress could not go ahead and ban the local manufacture by children. So instead, they ban the shipment of stuff. Now, Rachel, are you here?
Yes.
Rachel, what's that?
Sorry.
Yeah, Rachel B, that's right. So Rachel, let me ask this question. Isn't this law perfectly acceptable, right? They're not prohibiting the local manufacturer. They're just saying, okay, you can make child goods, child labor goods if you want. You just can't ship it across state lines. Isn't this perfectly consistent with E.C. Knight and Champion v. Ames? What's the problem here? Why is this a problem?
I guess will the states have the police power over the state? Is that what you're kind of getting
Well,
at? So,
but the states can allow child labor, right? These kids can work to their heart's content. They can, they can work as many hours as they want. But the only problem is then the manufacturer can't ship it across state lines. Why can't Congress do that much? Why can't Congress ban the locally manufactured goods?
well, I would say it's because they don't have an enumerated power.
But they can, but this is Gibbons, right? E.C. Knight. They can ban the shipment of the sugar. They just can't ban the manufacturer. So why under E.C. Knight, why is this case the way it is? Isn't it, okay, you
Well, I
can't,
guess it's manufacturing of like what the kids are actually manufacturing as opposed to.
but Congress is not regulating the manufacturer, they're regulating the shipment.
Well, I guess, okay, and then it's also the age of the employment.
But they're not regulating the age, are they? All they're saying is, if you make it, you can keep it in with one state, but if you ship it, it's a federal crime.
Yes, that's correct. What is the question?
How do you reconcile this case with E.C. Knight?
I guess maybe back to the indirect direct test where this is directly.
But this is directly regulating interstate commerce. It's direct, it's not indirect, it's direct.
Yeah.
Alyssa, what do you think?
Would it be that because they were trying to push the powers of the Congress onto the state to police it, and that's not what they're for? They were trying to
I think I know what you're asking, Alyssa. What do you mean push their powers onto the states? The Congress is not telling the states what to do. The states can allow child labor if they want. Why is this problematic?
that they aren't trying to actually regulate what the states are trying to do. They're just trying to police the states into what they think they can do.
But how are they policing the states? They're not telling the states what they can do or not do. Why are they policing the states?
They're kind of like punishing them for like not punishing, but like kind of, okay, well, if y'all want to do it that way, then here's your limit, and like they're trying to limit people.
Okay, I think you're getting closer, Melissa. What is Congress's real purpose here? Is Congress actually concerned about the shipment of the goods? What's really motivating their decision here?
They're trying to like control the power of the state.
Yes, right? Can they do so directly? Okay, now we're in business, right? So I thank you, Alyssa. So what's going on here is the court says Congress is lying. They say they're trying to regulate the shipment of goods, but that's not really their intent, right? Their purpose is actually different. Their true aim, their true goal is to intrude upon the state's police power, right? Their true aim is to intrude upon the state's police power. What the court's saying here is that this is not permissible. Congress can't assert power number one to regulate interstate commerce as a way to actually regulate local labor conditions, right? Congress can't regulate the minimum age for labor, yet at least. And they can't do so indirectly. In other words, if you're a business and you can't ship your goods across state lines, you're in a very tough spot, right? You're being punished. In this regard, this Congress is punishing businesses for what they do locally, and this they cannot do. All right, does that make sense? Joseph, you here?
Yes.
So let me try and ask you the same question I posed a minute ago. Can you reconcile this case with EC Knight? Can you line this case up with EC Knight?
I saw it kind of similar in how they're both trying to control the competition aspect between the states.
Well, let me try this again, right? EC Knight held that you can't ban the local manufacturer. Okay, you can only ban the shipment of the sugar. Well, in this case, you're banning the interstate shipment. You're basically banning the sugar being mailed. Does Hammer go further than EC Knight? Which is a stricter standard?
So this goes further than that.
Yeah, how so?
That you can't prohibit the shipment.
You can't prohibit the shipment if blank, fill in the blank. You can't prohibit the interstate shipment if blank.
If, I guess it was manufactured under the laws of that state.
No. Congress says we don't let you ship the sugar because blank. Because what happened?
Because of the child labor laws.
Yeah. Ooh. Very close. What was Congress trying to regulate here? Did they actually care about the interstate shipment?
No.
What were they actually trying to do here?
They're trying to encroach on the state policing power.
By doing what?
By not allowing the shipment of something that was legal in that state.
And then what's the effect of that law? What will that basically do to the state?
It would nullify their state law.
If you're a business owner and this federal law is in place, do you employ children?
No.
Bingo. Okay, that's it, right? Thank you for that. In this case, the court says Congress can generally regulate the interstate shipment unless their true aim, unless their true goal is to standardize local conduct, is to regulate local conduct. In other words, Congress can't rely on its commerce power to go after local decisions that are in the police power. Questions on Hammer? Yes, James, go ahead.
So is it a good general rule that we can always try to use the means-end test from McCullough about whether these things are actually commerce or not?
I like the first part of your question, but not the second part. So the first question is...
Or necessary and proper, I don't know.
Yeah, I know what you meant. It's okay. In any question about federal power, can you look to the necessary and proper clause? Yes. Always look to the necessary and proper. That's absolutely correct. But you don't need the commerce clause to support the necessary and proper clause. The necessary and proper clause can stand on its own 2 feet, right? You don't need the commerce clause to back it up. So just at the very end, you slipped in the word commerce, which has made your question a little bit off.
So I guess the real question is, can we always apply that means-end test?
Yes.
as
Yes.
a determining factor?
Yes. Yeah. And even where the court's doesn't say it's applying it, you should apply it anyway. You should think about it.
Thank you.
Yep, my pleasure. Are you in the building, by the way?
Yes, sir.
How is it? I've not been there in a while. Is everything okay there?
It's a ghost town, but there are probably 2 or 3 students per floor. And
Is that right? Are you by yourself in a classroom now?
In a study room.
Oh, study. Are they easy to get now?
Yeah, because the whole system's down for reserving them, so they're just all open.
Oh, lovely. Okay, well, I'm glad you're saying they're safe and sound. I've not been in the building since March. That's why this hair keeps getting bigger and bigger. All right. Thank you for that, James. Justice Holmes dissented, and he argued that this is inconsistent with E.C. Knight, and Holmes would go even further, that this is Congress actually regulating interstate commerce. This is like Gibbons, that this law goes too far. Okay. Now you should know for your notes that that E.C. Knight and Hammer are no longer good law. I said again, E.C. Knight and Hammer are no longer good law. They will be overturned during the New Deal in the 1930s. We'll get there, I think, next class, maybe the class after, I can't remember. Champion v. Ames is still good law. And indeed, Champion is still cited for a rule that the power to regulate includes the power to prohibit commerce. That's not obvious. It's not obvious that the word regulate means prohibit. But Champion held that, and that's the rule we have. So Champion, I think, is still good law. Hammer and E.C. Knight are not good law. The other case from the 1860s, well, we know that Knox overturned Hepburn. As for Dewitt, it's not a very significant case. I can't imagine you'll ever come across it. But I suppose it's good law. It's never really been revisited. Questions so far? All right. If you have your 100 cases book, turn to page 22, please. If you don't, I'm going to put on this screen very briefly because I want to walk through. I'd like to walk through. Where is it? Oh, I see what's going on. Sorry, just give me 1 second. It's this chart called the brief history of implied powers. Okay, the screen sharing is not working for me right now. Page 22. I'm sorry. Oh, that's what I wanted to close. All right. Okay. All right, this one I do. Okay, so page 22. This is a good overview of where we've been so far. We haven't actually done that many cases this semester. But what you'll find is that as the semester progresses, we keep adding more cases to the list. And I think it's helpful to keep this sort of chronology in mind as you go through the semester. So what this chart is supposed to depict is how broad has the court read the court's implied power? I'm sorry, how broad has the court read Congress's implied powers? Again, when I say implied powers, I'm speaking of the necessary and proper clause. You have the enumerated powers, that's what's expressly enumerated, and you have implied, that's which is understood to back it up. So let's just go through this one at a time. The first row we have involves the necessary and proper clause at the time of the founding, which is the first Bank of the United States, chartered in 1791. There was no court case right away about that. But the necessary and proper clause was in the background. And you remember we had debates between Jefferson and Madison on one hand and Hamilton on the other. And Madison and Jefferson took a very strict view. They said Congress is going to do that which is absolutely necessary, that which is strictly necessary to accomplish a goal. Does Congress really need a bank? No, might be helpful, but they don't need it. Hamilton took a much more permissive view. He said, well, if a bank is a useful means of regulating commerce, then they can do it. And then Washington, I think, probably agreed with Hamilton. Then we get down to the Marshall Court. And we have two cases. McCulloch v. Maryland involved the Bank of the United States. And here Marshall basically adopted the Hamiltonian reading, that having a national bank is a useful way of regulating commerce. It's a useful way of regulating taxes, right? So even though there's no express power to create a bank, you can imply it. You can stretch it out from the text of the Constitution. Gibbons was not a case involving enumerated powers that are implied, because it was about expressly granted powers. It was about the power of commerce, the power to regulate intercourse, the power to regulate navigation. So the necessary and proper clause wasn't really relevant to this case. Okay, I skipped the case of Prigg this semester, unfortunately, so we'll have to just ignore it for now. But then we get down to the Chase Court. We have three cases. Dewitt was about the oil, and the court held that Congress did not have the power to prohibit the local sale of oil. Again, prohibit versus regulate. See that those words actually make a difference. They banned the sale of the propane oil. And the next case, Hepburn against Griswold, held that Congress did not have the power to require legal tender. Right? So it's a fairly narrow. But then we get to the 1871 case, which is Knox against Lee. And look how broad this power is. It goes all the way out. All the way out. And what the court said in Knox v. Lee is basically any power which relates to something Congress can do is enough. It doesn't have to be a tight connection. It's just a general loose fit. It's a very broad scope of implied powers. But as these implied powers get bigger, the state's reserve powers shrink, right? As this chart goes to the right, the state's power goes to the left. So it's always this sort of inverse relationship. Then we get down to the progressive era, and we did three cases today. E.C. Knight, Champion v. Ames, and Hammer v. Dagenhart. E.C. Knight, I think, contracted the scope. They said, well, Congress can regulate the shipment of these goods, but they can't regulate, right? They cannot regulate the manufacture. And then we get to Champion v. Ames. Right? Champion v. Ames didn't cite the necessary and proper clause, but I think you have to incorporate it into any answer you give. And the court holds that this power to prohibit also includes the power to regulate. So I think Harlan's opinion in Champion reflects a broader reading of implied powers, even if he didn't really say so. And then we get to Hammer v. Dagenhart. Hammer didn't overrule Champion v. Ames, but Hammer suggested that even if you're regulating interstate shipment of goods, if the true purpose is to regulate local labor conditions, Congress can't do it. Congress cannot regulate the local labor conditions. That is for the states to decide. Okay, I'm going to stop the screen share. I'm going to turn on the minute poll, which you're welcome to use. And I've got a minute left. If anyone has any questions, please raise your hands if you have any. All right, well, please type in any thoughts you have, your summary of the case, your takeaway, what you don't understand. I'll do my best to address it next class. If you give me 10 minutes, I'll be back here for office hours. I'll be happy to address your questions. Anything else? No? All right, I'll see you all on Wednesday. Best wishes.